We will move very quickly on to the next part of our program, so we can ensure that we stay on track with our time. The next part relates to courts and arbitration in numbers. Our moderator is Dr. Professor Ken Wayne Mutuma. Please come up.
Now, I have a very difficult task. I have a very high-powered panel that is with us, and they've traveled from very, very far. And then, of course, I have, looking at the conference directors, the challenge of time, which we have to manage. So first, let me invite the panel and then contract with all of you, just in line with what Senior Counsel John Ohaga had said on how we manage time in the next few minutes. So I'm very honored, and you have had them introduced, to invite to the podium our very own Honorable Justice Smokin Wanjala, a fellow of the Chartered Institute. Karibu sana. Please, as they come up, give them a round of applause. Really, really wonderful to have them. And then all the way, and I learned a few things in relation to his profile today. We have the Chief Justice, the Honorable Dr. Mumba Malila. Yes. All the way from Zambia. I learned that he's a fellow. I also learned that he's an academic. I was going to poach him because that is something that we have common interest. And then we have, again, the Honorable Justice, retired Charles Kajimanga. Again, he's been introduced to all of us. Welcome, Your Lordship. Very, very good to have you with us. And last but not least, we do have our chair present, Jacqueline Waihenya, Chartered Arbitrator. Karibu sana. So we will try and keep this very, very brief. For those of you who want more details on their profiles, please look at pages 62, 64, and 65. You will find a wonderful, rich profile. I just picked a few things. One, that quite in common with Justice Mwongo, that the life of C.Arb in Zambia has a lot to do with those two gentlemen. I also learned that they are prolific writers. There's something that we're doing later on. There's a handbook, and I learned Justice Kajimanga has been an author of a handbook in Zambia, an arbitration handbook. So he will be very delighted to hear that we're following in his path. I also learned that they have a lot in common because they have an illustrious career, both in private practice, as arbitrators themselves, and also in civil society, human rights. So a lot of the issues that we're talking about in the language of sustainability, they would be fully seized off in their past. So to the panel. I have a set of three questions, and I'd like to make them brief because this is meant to be a roundtable. And the majority of the questions will come from the plenary. A lot of people have made every attempt to be here just to interact with the honorable judges. The first, I think, is around the balance and the trends from each jurisdiction when we're looking at the principle of party autonomy and the history of arbitration, which seeks finality to underscore two very important needs that the parties may have. The need of cost expediency, the need, again, of swift justice. And then on the other hand, there is the jurisprudence that touches on judicial intervention, that this is not a blank check, that there is somewhere that the courts maintain a role, and for the right reasons. We've had a lot of jurisprudence in this area around Section 35, when an award can be set aside, and the right to appeal in those specific instances that a decision goes in that direction from the High Court. We will start with 5-minute reflection from the panel. And Justice Wanjala, this is your home. So playing host, your thoughts around that delicate balance between party autonomy and judicial intervention. Welcome.
I think we cannot start reflecting upon that balance without, again, doing what a conservative practitioner or thinker like myself must always do, going back to the basics of arbitration, the foundational principles. Why arbitration? And then, of course, quickly we go into the efficiency, autonomy, economy of time, cost, and all that. So that is then informs a reflection about the need for balancing autonomy and judicial intervention. Autonomy simply, as we all know, meaning that we should allow parties to determine how they want to relate to each other in an environment, in a process. And this also brings to the fore quite quickly how they would want to resolve their disputes. That is party autonomy. And if therefore parties determine that in the process of their relationship, they would like their disputes to be resolved through an arbitral process, then it's for courts to respect that. But the courts can only respect that in a given context. How do we bring in courts in the first place? Which means, therefore, that arbitration does not and cannot have existed in a vacuum. It comes out of a court process, meaning, therefore, that arbitration and formal court processes are one and the same. And if they are one and the same, then there must be a tension at one time or another. And therefore, the role of a court is to respect those basic principles, is that the extent to which the court intervenes must be dictated by the context, by those principles. And if a court, and at the back of every judge who is faced with a dispute arising from arbitration or an arbitration process, is this question: to what extent am I being or staying true to those foundational principles? If my intervention goes beyond staying true to those foundational principles, then I am not maintaining a balance. And the balance here, therefore, is for the courts of law to facilitate that process, but also to prevent what would constitute an abuse of process, either procedural or sometimes, in fact, substantive, in terms of what constitutes an abuse of justice. So it's a question of maintaining that balance. Respect the foundational principles, respect the party autonomy, respect why arbitration in the first place. But remember also that courts, being part of that process, just do the limited what a court must do. Do not overreach. So it's a question of maintaining balance, avoiding judicial overreach, and staying true to those foundational principles.
My Lord, the Chief Justice of Zambia, kindly weigh in on those opening remarks. There were certain words that were used: respect, the basic principles, facilitate, and avoid abuse. What are your thoughts looking at the courts in Zambia when it comes to this idea of facilitating arbitration and not necessarily frustrating the goals of the intent of the parties in arbitration?
I think the law generally does respect the sanctity of agreement. When parties agree, it is not the role of the law to try and frustrate those agreements. Arbitration, as we know, is inspired by agreement. The parties do provide through agreement beforehand that in the event that they develop a dispute in their relation, they will go the route of arbitration. And we also know that once a dispute arises, then agreement becomes very difficult to sustain. The same parties that had agreed before they got into some kind of dispute to refer a matter to arbitration in the event that the dispute arises will then, once the dispute has arisen, fail to reach agreement. And in those circumstances, it obviously means that the broader purpose of the law, i.e. maintaining order, maintaining peace, the public policy side of the law should kick in. Hence, the support that the courts now come to give to the parties. The role of the courts in this sense, I think, is one that is supportive. First of all, it will help the parties resolve the dispute. But secondly, it will also be respectful of the parties' decision. And this is where I think we keep saying that balancing those two can be quite an enormous challenge in some cases, particularly given that there is a tendency for one party at least to try and abuse the process. So my thinking about this is that the concept of party autonomy is the linchpin upon which any intervention by the courts is supposed to be premised. The court is supposed to give what is necessary, but also it should have respect for the option that has been taken by the parties to go the route of arbitration rather than mainstream litigation. Now, it's a very delicate balance to make every time parties who have agreed to arbitrate matters come to court. So the rationale for judicial non-interference, I think, is all premised at the end of the day on the respect that we ought to accord to party autonomy, the decision by the parties themselves to ensure that their dispute is settled by arbitration. And therefore, the general approach of the courts should be to disincline jurisdiction. That's like the starting point. We are not going to interfere except, and then you try and define those exceptions. I think that is what I would say at the moment. Thank you.
Thank you very much, Your Lordship. What are the sort of judicial trends that you've picked around this issue? And it could be within Zambia, I know you've also done a bit of work in South Africa. When it comes to the finality of the word, those sacrosanct principles, and possibly even cases where judicial intervention has gone beyond what's provided in statute. Please.
People opt for arbitration because of the finality of the decisions that are made in form of an arbitral award. And that's an advantage because it helps to shorten the process by which a successful party can enjoy the fruits of his award. So, and it's really a benefit in terms of business that when you are owed money, you get an award which is final and binding, and all you need to do is to enforce it if the unsuccessful party is unwilling to comply, and the process is shortened. rather than going to court where, because of the appeal process, you end up taking like 2-3 years before you can enjoy the fruits of your judgment. Yes. But while appreciating the importance of the finality of an award, I think we must be mindful of the fact that there are instances when a final award cannot be enforced. And most of our domestic legislations, which we derive from the UNCITRAL model law, the New York Convention, they set out circumstances when a final award, though final, cannot be enforced. And these are obvious. If there is evidence of say fraud, corruption, non-adherence to due process, a party in the proceedings was not given an opportunity to present his case, the court, notwithstanding that the award is final, the court must come in to intervene. Why? Is to ensure that there's integrity in the arbitral process, to ensure that public policy is not violated. And so, while we appreciate the finality of an award, and I think that courts must respect that, rather than to unduly interfere with the execution of final awards, it's only in very, very limited circumstances that a court must intervene. Because if you intervene willy-nilly, what you are doing is that you are undermining the arbitral process. You are discouraging parties from going to arbitration because they will say, after all, we'll end up in court. So what's the point of going to arbitration when we'll end up in court? So it's better that someone just goes straight to court. So that's my take on that.
Are we there, Madam Jacqueline Waihenya, as I bring you in? There has been a series of cases in this jurisdiction, Newto, Synergy, Cape Holdings, that have raised fundamental issues for the practitioner and caught the attention of institutions like yourselves. Building up on that last remark, are we there where you still feel safe as an arbitrator that this scope and space is protected and you have a healthy relationship between the arbitral proceedings and the judicial structures? Please.
Are we there yet? It sounds like one of the questions that when we're going on a journey, some of our kids would ask us. And the journey of 1,000 miles starts with the first step, and we have taken several steps. What I'm trying to say in not so many words is that we are on the way. We are not yet there. And as we have navigated, and there are various practitioners who have navigated the court process, we always, I think that is the first thing we raise when we are going to court. We say the principle of non-judicial interference is fundamental, and indeed it is. And it's good to hear the judiciary say that, because when they say that, the journey is half complete. Because where we started from, there was a sense of entitlement of the judiciary to say, this is our space. You're actually encroaching on what really is a public service that the judiciary is playing. And I think for Kenya, and also works in Zambia, is that Article 159 says the judiciary promotes ADR. So as we have moved from 2010 to where we are now, in the court corridors, these arguments have been made. And it's also good to hear party autonomy coming out, like Honorable Judge Smokin spoke about. When judges start appreciating party autonomy, then we do know that we are on the right track. We are giving effect to what the parties intended, even if they change their mind. But when they were contracting, they intended that if there is a dispute, we will resolve it in this particular manner. And this is what we have framed, and the judges are breathing life into party autonomy. And the truth of the matter is, it is impossible, and it would have been impossible for us to get here without the role, the very important role played by our most significant stakeholder to stand up and say, yes, this is an arbitration agreement, the clause says, our Constitution says, the Arbitration Act says. Are we there yet? Yes and no. I think what I will start with, I think because we participated in the new to aggravate case as amicus, and I can see our counsel there, senior counsel, Kamau Karori, who did a sterling job. And when he appeared, I think one of the challenges that he faced at that particular point in time, when he was arguing the case for C.Arb, because we are the interested party, the dilemma was, okay, if you say that the courts have no role, what if there is a genuine case where things have gone horribly wrong and then you disempower the judiciary? And so, obviously, when we did get to that point, and I know when the decision came out from the Supreme Court, I'm not saying anything about the decision actually breathed life into what our legal framework provided, and in the context of the new to case and the way the Arbitration Act is framed in Kenya, I believe they gave us the right parameters to the extent that judicial non-interference, yes, but if there's something that is manifestly wrong, has gone to the other side of the tracks, and we do know, it is not an African thing, we do know that things can go wrong and may go wrong, and there may be a complete failure of justice, then the courts need to step in and right that frame. And the way they determine it is to say, take it back to the Court of Appeal. And the Court of Appeal will have a very limited, very small opportunity to consider, and it will be if there, and the word I think they use is gray, or everything outside of the normal and outside of what is ideal and ought to be put or breathed, the life that needs to be breathed into it. So standing as the institute, I think we expressed ourselves the way we expressed ourselves in the new to aggravate case. But, and this is now where I say, the Supreme Court got it right. I think we can say the Court of Appeal got it right. But there are emerging jurisprudence, emerging decisions that do give us cause for concern.
So we are very privileged to have Senior Counsel Kamau Karori here. And I'm sure when we turn it over to the preliminary, he may have something to say about that jurisprudence. I want to nudge us to the next series of questions, which is really highlights what you said, Madam Chair, that the judiciary is such a key and a fundamental stakeholder. In fact, everywhere we speak about making an area an attractive investment destination, the context is always about disputes and the attitude of courts towards arbitration. So, Justice Wanjala, you are the Director General of the Kenya Judiciary Academy. And I think you can speak authoritatively around capacity issues, around the relationship between the judiciary and appointing authorities, arbitral institutions, and what has been achieved, what more can be done. Remember, Jackie asked, where did it start and how is it going? I'm also looking at Justice Mwongo because I know he knows where it started, and hopefully he will, during the plenary, tell us about the beginning and where we are now. Karibu sana.
I think picking it up from where Jacqueline left is this is still an event. It is still something in process. And from the Kenya Judiciary Academy's vantage point is we recognize the need for the judiciary to be alive to the law and the process of arbitration for it to play that balancing role. For example, when we say that the judiciary, we go to look at the judiciary's role not necessarily from a negative point of view of don't intervene, but if you're not intervening, what are you doing to facilitate the process of arbitration? And so those three stages. And therefore, the Academy seeks to equip the judicial officers with the basic knowledge of how of the interplay between arbitration and judicial intervention. For example, just before the arbitration process kicks in, what would a court of law be required to do to facilitate that process? And we recognize that it is recognized by both the judiciary and arbitration practitioners that there are orders which only courts can deliver, can render, not the arbitral tribunals. At that stage, when the court gives an order, a preliminary order, the judge must ask, how am I facilitating this process? And then when it comes to the interim orders, when the arbitration process sets in, and then finally the enforcement orders of the awards. So basically what the Academy is now doing, and in conjunction with the institute, our institute here, is to develop a model which then will equip the judges and magistrates with fundamentals of the law and process of arbitration, so that again, let me say is that sustainable arbitration is a tripartite responsibility. It is not just the courts. It starts with the parties themselves. That if you are asserting your autonomy, then you must remain to that call of autonomy. Because if you fashion your application, you invoke the intervention of a court that would necessarily destroy that autonomy, then you have a role, you have a responsibility. And the tribunal has a responsibility. Always asking itself, what is it that would make the High Court, for example, in Kenya, set aside my award? And you go back to what the law requires of you. And then the court will say, what is it that should make me tilt towards intervention as opposed to non-intervention? So I think we are developing such models for judges and arbitration practitioners. Thank you.
Anything that we can learn in that regard, my Lord Chief Justice, what is happening in Zambia around this relationship between institutions and the courts and capacity and so forth? Thank you.
Yes, thank you very much. In Zambia, unfortunately, we don't have an operational judicial training institute as yet. We only appointed the board of the institute, I think, was it last month? So it's yet to be operationalized. But as of now, the Chartered Institute, the Zambian branch, does conduct some courses. The only difficulty is that the courses that they conduct are all intended for individuals that want to end up being arbitrators ultimately. So there's all these layers of programs, associate, member, fellow, and so on, which is perhaps not very ideal for judges for now, if the judges intend to continue to be judges, not arbitrators. What we are doing internally as judiciary, pending the judicial school coming up with a properly tailored course, is to have these short courses just to orient judges to think of the supportive role and not the frustrating row of the courts to arbitration. Because I think this link between arbitration and the courts is very, very important, and it has oftentimes been misunderstood. If some of the jurisprudence that has been generated by the lower courts in the hierarchy is anything to go by. We have had instances where it is very obvious upon reading a judgment that the judge does not appreciate the principles of arbitration, and perhaps they have taken this jurisdictional theory, assuming jurisdiction for all disputes, to a level which they shouldn't, in the light of the existence of an arbitration agreement. So I think what we need to do, and what we are doing, I think until such time as we have properly structured courses, is to orient these judges every time we have workshops and we have seminars on what not to do. Because judges should be the first ones to understand that all the pluses of arbitration risk being undermined by the manner in which they conduct matters that come to them from an arbitration environment. So I think for now, we don't have anything properly structured in the same way that my colleague Justice Smokin has explained it in Kenya. But I think it is something that we'll be working on, and we do hope that we'll have some lessons to draw from Kenya, of course. I mean, if Kenya has already done it, it's easy for us to see what best practices we can pick up from there. Thank you.
Thank you very much, Your Lordship. Now, we are at 24 past, and I don't want to shut the audience out. Because the most important part of a roundtable is just to get one or two comments and questions. We haven't covered, I know, a very important subject of this theme, sustainability. Thankfully, Mr. President, you did justice with your presentation, but there are questions about that tension we had yesterday between making this an investment-friendly destination and at the same time these new generation agreements that have emerged about protecting our jurisdictions, the environment, ESG, and so forth. I'm sure that will come from the floor. So it's open. Any hands, just quick comments? I will be there's one here and one there. I think the conference director will illustrate how short a question should be. It should not be a PowerPoint presentation, just very, very brief.
Yes, very, very short. My question is directed to you, Mr. Chief Justice. With respect to the practice in Zambia, as I understand it, your judges in Zambia are also at liberty to practice as arbitrators. How do you find the balance between allowing judges to practice as arbitrators as well as carrying on their judicial functions, especially when you consider that eventually it may well be that awards may be challenged back to the same judiciary? Thank you.
Thank you. Another question there. Yes, the Honourable Justice, that is the first female chair of the Chartered Institute of Arbitrators, and she's given us a lot of grace with that name, Jackie. A lot of Jackies seem to flow into merits. Welcome, Judge.
Thank you very much, all of you, for very kind and warm words. So I'm extremely delighted to be here. Now, mine was on issue of the tension and conflict between the party autonomy and the intervention of the court. And my feeling is that then there's need for us to ask for the amendment of the Arbitration Act, because for a long time we have tried to have it amended, because it's very clear that you can only do certain things upon the application of upon the agreement of the parties, or if it's outside Section 10. That's the only time when you're going to intervene, as provided under the Act. So when I look at even Section 39, and even when the court comes to intervene even in questions of law, it says that where parties have agreed. But we have been seeing that constantly as courts we are intervening, which is okay, because there'll be a time when you require it. But I think there's need for us to amend the law so that we avoid that tension and conflict.
Thank you very much. Honorable Chief Justice, first question.
Right, thank you very much. Judge arbitrators in Zambia. Yes, presently we have judges that do arbitration in Zambia. And we have had instances where their arbitral awards have come into the court system being challenged for one reason or another. And the usual thing that happens is that those judges obviously would have to recuse themselves from dealing with those particular issues. But the bottom line is that, yes, it's very, very untidy to have judges do arbitration. The problem, as I see it, is much wider than an individual judge recusing themselves from a matter, because once a judge, say, of the Supreme Court has served as an arbitrator, and the challenge to that award is being launched in the High Court, a High Court judge looking at an award given by a judge in the Supreme Court is bound to have all these chills. What will happen if I overturn? You see, a judge is a judge, and they still think in that regimented way. They still think about the order of seniority and this and that, and it doesn't matter in the circumstances in which the decision is made. So the problem is definitely there. It is regrettably a historic problem. We all got into the judiciary and found it. What did we find? We found that there was no law proscribing judges from performing the role of arbitrators. And I think the reason is simple. Until about the year 2000 or so, arbitration was not a very big kind of activity in Zambia. And we had very few people. In fact, Justice Kajimanga here, together with his colleagues, were very instrumental in getting the Chartered Institute come on board, and only after it came on board did we have a proliferation of individuals joining to be arbitrators. What originally happened, as I understand it, is that those that started with the arbitration movement, strictly speaking, were in private practice initially. And then they moved on to the bench, Judge Kajimanga being one of them. They moved on to the bench, and there were still very few. There was a very small pool of arbitrators available. And they were being asked to arbitrate because they were the people available. And I think now we've come to a point where there are so many other arbitrators who are not in the judiciary. It is very untidy to continue to have judges doing arbitration. And luckily, I think, and the chairperson of the Zambian branch of C.Arb will speak to it, I think there has been a movement of late to make amendments to the Arbitration Act. And the possibility is that that situation will be remedied then. So can I take advantage while I still have the mic to attempt to say something in relation to what the former chair has said? It's part autonomy and court support and the need to amend the law. I don't know what the Kenyan Arbitration Act says about court intervention, but I think if it is aligned to the model law, then there will be very little reason to amend it, because the model law does in fact specify instances in which court interference, or not interference, but court interference, court intervention, I think that's the word, will be allowed and when it will not be. So I just thought I should raise that. Thank you.
If you excuse me, if I might just intervene on Justice Kamau's question. There are proposed amendments to the Arbitration Act. Those are already sitting at the Attorney General's chambers, waiting to go to Parliament. So there are proposed amendments.
Judge, it would be very difficult for me to pass your hand.
Very good. So what I was about to say is that arbitration in Kenya has been a journey, just like Jackie said. And if you look at the judgments of our courts around 2005, you will find that the key discussion was always about whether or not the court's jurisdiction could be ousted by a thing called arbitration. What on earth? Who dare, rattle the court's almighty and supreme power? After 2010, with the advent of Article 159 and the idea that that paradigm shift that the judiciary, in exercising its authority, must promote, it's an obligation, must promote alternative dispute resolution, I think we have moved a long way, and I like to look at this from a long telescopic point of view, because when you go back to the 1990s, I recall, and maybe Njoroge will recall, when we were in the branch, one of the early branch committees, we attempted to try and introduce judges to arbitration in maybe 92, 93, thereabouts. And we were chased away. Get out of here. Who do you think you are coming to train judges or to tell judges about law of arbitration? Who are you? Judges could not be trained in those days. But now we are in a totally different environment where the Supreme Court has, I think, 6 of the judges are now fellows. And therefore, there is the arbitration principles are becoming part of judicial practice. And so there's a huge difference, notwithstanding the little hiccups we have with the individual cases. There will be hiccups, and that will continue because parties who are dissatisfied with decisions will always go High Court, Court of Appeal, and if possible, the Supreme Court. So that will continue. But the space has been so opened up in the judiciary. I think I was trying to count the other day the number of judges who have who are either fellows or members, MCIRBs, and we must have about 25 or so who are already involved in that kind of training. And therefore, the opening up is what excites me compared to the history that we came from. We are no longer talking about jurisdiction. We are talking about more subtle nuances of arbitration. So I'm very grateful for even to be involved in a conference like this. Thank you.
My name is Justice Visram of the High Court. I'm in the Commercial and Tax Division. I want to thank the panel for their insights and their reflections. I have a short comment and then I have a question that I wanted to present to the panel. My comment is that at the High Court level, in my division, we approach arbitration from the principles that you have spoken of, and I think we all agree that the starting point is non-intervention. Our role is to assist the process, the arbitral process, and to supervise as and when it's necessary. And I think in this regard, we look at supervision in order to maintain natural justice and to ensure the fairness of the process, so that arbitration does not deviate from those purposes and objectives outlined under the Act. And I talk about the Kenyan Act and I refer to the English Arbitration Act. The English Arbitration Act in particular has been very helpful for us in Kenya. Section 33 of the English Arbitration Act, which talks about the general duty of the tribunal, actually governs how we treat arbitration in Kenya. And we look at that as being the objects and purpose and how we as a court should also understand arbitration proceedings. So one of the things I would say is that when we think of arbitration here, we have a lot to learn from different jurisdictions, from different acts, and as much as we can learn from the English Act, the question I have for our esteemed panel today is with regard to public policy. Now, the Kenyan Arbitration Act at Section 35 provides for the various grounds under which an award may be set aside. That mirrors the model law, ancestral model law. It also mirrors the New York Convention in terms of situations where an award may be refused recognition and enforcement. So the grounds are not new, but the application of those grounds may differ. And one of the struggles that we're having today in the High Court is that lawyers come to us and they're brilliant. And they all want to tell us what public policy is and what we should consider to be a particular area that falls within the category of public policy. So recently we have had awards being set aside or set aside in part on issues such as the interest rate that was applied by the arbitrator. We have, of course, in the UK, illegality, which is public policy, and we know about those. But I wanted to ask the panel, in your jurisdictions, are there any areas that you can tell us that are now firmly part of public policy and which you have considered to be a valid ground for setting aside an arbitral award so that we can understand what's happening there and whether or not the same may be applicable here? Thank you.
And let me say that Justice Visram, when you joined the bench, we lost a formidable trainer. He was very, very keen in the C.Arb trainings. Justice Kajimanga, you want to respond to that and probably weave in the question about AJS systems and law reform. It is a big question that has been the theme of this conference right from the beginning, particularly with our constitution and some of the pronouncements that have made inroads into the area of private law. Any lessons that we can learn from Zambia?
Let me attempt to answer that question. Well, our act is modeled on the ancestral law on arbitration. And one of the grounds for setting aside an award or for refusing enforcement is if if it's against public policy. Of course, as we all know, public policy is a very vague concept, and it's subject to a lot of inconsistent interpretations. We haven't had so much jurisprudence in my country dealing with public policy, but where there's evidence that there was fraud or that there was an illegality, that really would fit into the category of public policy. Something that is contrary to to morality, that wouldn't pass. Yeah. So I mean, it's clearly stated in our Arbitration Act, but we haven't had a lot of jurisprudence around that area where the public policy has been properly defined or articulated.
The time we have will not allow us to get into the meat of that, but it has, I think the global president cited a case where public policy now was taken to mean actually the arbitrators' fees, and then of course we've had interest. And everyone is looking at you, Justice Wanjala, to churn out probably some material in that regard. But I know the time that we have is very constrained. Ladies and gentlemen, please allow us to bring this to a close.